always used to lay you clean up the messes. Down on my knees, thought I couldn't stand up on my own. Turns out sometimes you're stronger alone.
So I'm going to start this episode with a disclaimer because we're going to be talking about legal matters. So the following podcast is for informational purposes only and should not be considered professional legal advice. We are not responsible for any losses, damages, or liabilities arising from the use of this podcast. Everyone has different individual circumstances. Laws may vary based on where you live. And the following is just a general discussion of various topics that may come up in your life. So with that said, I'd like to introduce today's guest, Kenesha, and I'm going to let her actually introduce herself a little bit, who she is, and what her background is a little bit as we get into some of these potentially legal matters.
Well, thanks for having me. I'm Kenesha. I am an attorney practicing in Baton Rouge, Louisiana. I've been practicing for about 15 years. I'm an ex-JWs witness, and I'm shy.
So that is quite an introduction. I like how you spun that off of the introduction from the normal episodes. So you've been practicing for 15 years, so you definitely have some experience there. Today we're going to talk about a few things I put out to the community, options for some questions, and there were some questions that we also already had and wanted to address particularly 4 different topics today. So we're going to talk about wills or end-of-life matters. We're going to talk about life insurance and some considerations there. We're also going to talk about emancipation and what that might look like. And then finally, we're going to talk about issues regarding blood, because that, for us who were once Jehovah's Witnesses, was a very legal matter. We carried a legal document in our wallets and purses, identifying that we would refuse blood transfusions. So let's go ahead and start with wills a little bit. And so when it comes to wills, because again, this is something that we never really talked about as witnesses. Legal matters, a lot of people didn't prepare for the future at all. There really wasn't much there. So what are the basic types of wills?
Okay. So before I answer, you did a great disclaimer. I just want to give just a little bit of an extra disclaimer. So I'm a Louisiana attorney. I'm barred here and I practice here. I'm not barred in any other states. I don't practice in any other states. And so my body of knowledge is going to pull from Louisiana law. There are some general concepts in the law that we can talk about, but for the most part, if I'm giving you, say, something specific, it's going to be Louisiana law. And again, it's for educational purposes. I'm going to give you like a general overview of legal concepts, not specific legal advice. So I just wanted to make sure that I give you that disclaimer so that you can take this information in that context. So different types of wills. First is we have a last will and testament, and we have a living will. And these are 2 documents that a lot of people get mixed up, or they use interchangeably when they're 2 different kinds of documents. So a last will and testament is a document where you're setting forth what you want to happen after you pass away. And in Louisiana, there are 2 types. There's an holographic, which is a handwritten will. And then there's a notarial will, which is a will that you usually get prepared at a lawyer's office or some legal professional. So there's that. And then there is a living will, which is actually a medical document. It's an advance directive, which you've probably heard, or if you're an ex-JW, you've probably heard, because the no blood card is an advance directive. And an advance directive is basically it's instructions for medical professionals. And it's basically saying, in advance of this circumstance that I might find myself in, these are the directions that I want you to follow regarding the care that I receive or I do not receive. So it's basically just telling your medical professional in advance, I want this or I don't want that. a lot of times you can designate a person who can give those directions in the event that you are not able to. So that's just a general overview of wills. Last will and testament, not a medical document. It's a testament, and then a living will is a medical document.
Okay. So is there anything that we as ex-Jehovah's Witnesses might want to at least consider putting in place in a living will that might protect us in some way from, I guess, maybe from witnesses that may be well-meaning, but maybe have different beliefs and would try to speak into our lives and medical decisions specifically?
Yes. So this is where living will come into play. And another disclaimer, this is what we do as lawyers, give disclaimers. But anyway, I'm not a medical professional. I did consult with some medical professionals who gave me their advice on it, so I'll relay that. But don't take, if I'm saying this is the way that it happens in the medical field, like, don't take that as gospel. So just that disclaimer for that. But anyway, as far as I've seen or heard, the medical professionals that I've consulted with, the consensus with them is that in the event of a medical emergency, the priority is going to be stabilizing the person. And so, and this, I didn't know this before I, did some digging into it, but apparently first responders don't even consider things like advanced directives, unless it's a DNR, or do not resuscitate order, because they would be the ones resuscitating or not resuscitating. But for them, the priority is just stabilizing you until you can get to a place where the living will come into effect, when the doctor is assessing, okay, now that this person is stabilized, what else needs to be done? And if you aren't able to make that decision, that's where the living will comes into play. Another consensus with the medical professionals that I talk to is that if you are unable to communicate your medical wishes, then, and this is actually part of the law, if you don't have a document in place that is going to say, this is what I want to happen, or this is who you call upon to see what I want to happen, then it's going to go by law who gets to make those decisions on your behalf. So here in Louisiana, the first priority, the person who would make that decision is going to be your spouse. And after that, if you don't have a spouse, it'll be your adult children. And then if you don't have adult children, it'll be your parents, and it goes down the line like that. So if you have a believing spouse, it's important to have that document in place. If you don't want that spouse to tell your medical professional that don't give this person blood. If you have adult children who are believing, you don't want them to make that decision for you. It's important for you to have that living will document in place to say, no, this is the person that I want to make this decision for me instead. And then, of course, like, bodily autonomy is going to be paramount in these situations. So if you can make your wishes known beforehand with a living will that you have on record in your medical file, then that's best. It's good to let your primary care physician, if you have one, it's good to let them know, well, these are what my wishes are. And then these are things that you can actually put in your medical file. I don't know if you're familiar with MyChart, but it's very widespread here, and I've seen it used in other states as well. It's kind of like a centralized database where medical professionals can pull your information if you happen to be involved in an emergency, or if you're going through some kind of medical procedure. And so I looked in the app, actually, there's a place for advanced directives where you can go and upload that document so that it's part of your permanent medical file. So basically, you just want to make sure that your wishes are known in however way you can make them known, so that doesn't get to the point where somebody else has to make that decision for you. But if it does get to that, it's good to have that living will in place so that that person is designated make that decision or to let your decision known, because ideally they're not making the decision for you. They are enforcing or informing your medical professionals that this is the decision that you said you wanted to have made before you got into this situation or this circumstance.
So that is something that when we talk about blood later, we'll talk about potentially how you could have a document on you to allude to any living wills as well. But I think that my chart, yeah, we have that here in Kentucky and Indiana. I live on the border, and I've used it in both states, I believe. So that's something that we have as well. I don't know, of course, where everyone lives, but that's an excellent idea. If there's something like that available that's accessible and accessed by so many different medical professionals, it'd be a great place to have that document. When it comes to a last will and testament, is there anything that we might need to consider to make it difficult to challenge that wills once we're gone, in case there is someone who is in our family, or I guess perhaps maybe even not in our family, from the cults, who feels like they might be entitled to something? Is there anything, because some people would be concerned that if they had something that they were leaving behind, certainly we would not want it to go to something we did not support, and it certainly did not support us. So is there anything extra we would need to do, or just something we would do in the last testament type of will from the beginning anyway?
Yeah, so I don't know if it's anything extra. I mean, the basic format of the last will and testament is going to cover that. Just a little bit about both forms, because like I said, this is Louisiana. Other states may allow both forms as well. But for the holographic will, which is what we call a handwritten will, it just needs to be in the person's own handwriting, signed and dated on every page. And then after that person passes away, they'll need to have a witness to testify and say, this is that person's handwriting. I know that to be a fact, and I know that they wrote this. And then, that if it's in the proper format, that will hold up. For the notarial will, there's a lot of technical and legal requirements for that. So I definitely recommend seeing a legal professional for that. There are some online sites. I know that LegalZoom is one. I think Rocket Lawyer may be another one where you can get these kind of fill in the blank type wills. I do urge caution with those, just because, especially in Louisiana, our law is different from every other state's law. And so some of those companies that may not be based in Louisiana may have forms that don't conform to Louisiana's law. But no matter what state you're in, you want to make sure that if you get one of those forms, you take it to a legal professional to have it reviewed before you finalize it. And in a lot of states, I know here, like, that is required. So you need witnesses, you need to have it notarized. And then I know, like, when people hear go see a legal professional, it's, they think it's going to be a lot of money. For inexpensive legal services, you can call your state bar association. A lot of times they can refer you to attorneys who have low cost or pro bono services, which is free services. You can call the law schools in your state. A lot of times they have law clinics where law students will provide services to you at low cost. So those are two things that you can kind of think about as far as getting these things done without a huge cost to you up front. As far as challenging wills, anybody can challenge a will. Like, anybody can file a lawsuit and allege something. It's just, so there's nothing really you can say to prevent a will from being challenged. However, to challenge it successfully, you have to prove whatever you're alleging. And so the things that you want to make sure that you're cognizant of when you're creating the will is that it's in the proper format, because a lot of people will attack it on that. In Louisiana, it's very specific, the language you need to have in it. the fact that you need to have witnesses, the fact that it needs to be notarized if you're doing a notarial will, if you're doing a handwritten will, the fact that it needs to be signed and dated on every page. So just, the format requirements, you want to make sure that those are done correctly so that it can be challenged or it can be successfully challenged from that aspect. And then when you are creating the will, you want to make sure you're in your right mind. So you want to make sure you're not inebriated, you haven't done any drugs or alcohol beforehand. Don't get it when you're coming from a medical procedure, you may still be affected by drugs that you were given then. So just want to make sure you're clear and you're sharp. And then, of course, if you're doing a will with a legal professional, they're supposed to ascertain that for you. And then the good thing about doing it with a legal professional is that if it's challenged, and that person who ascertained all these things while you were doing it can testify and say, oh, no, I did this. This person was okay when they did it. And this is how I know because I asked them this and they answered correctly. So, just those sort of things, just make sure it's done correctly. And that will lessen the chances that somebody challenges it successfully.
I know this wasn't in the list of questions that I provided, but when should someone consider getting a will? Should we all probably consider that?
That's a good question. A will is a good thing for anybody to have, just because when you're not here, after you pass away, you can't dictate what happens to your belongings, to your children, to your assets. You can't dictate that after you're gone, obviously. And so if that's something that you are concerned about, it's good to have a will. It's good to know the inheritance laws in your state, because a lot of times, well, if you don't have a will, in Louisiana, again, if you don't have a will, then your assets are inherited by your heirs by law. And so there's an order of succession, there's a lot of factors that control that. But if you, say if the law says this goes to your children when you pass away, if you don't have a will and you don't want it to go to your children, then you need to do a will to say, I want it to go to this person instead. So if the inheritance laws are formulated the way that you want them to go, like the person that the law says inherits, if that's the person you want to inherit, then you may not need to do a will because the law may take care of that. But again, it's always good to do one. I think, I know there is a cost. It's not super, super expensive, especially if you can find a good online one. So I think it's good to have one, even if you have just a checking account, if you want to say who you leave the balance of your checking account to, you can do that. If you have minor children, you can designate who you would want to be their guardians in the event that you pass away. So there's funeral burial plans you can put in a will. So, there's a lot of things that you can include that don't have anything to do with assets. But I think it's still a good idea to have one, whether you think you need one or not, whether you think you have enough assets to warrant having one.
Yeah, I think that, and one of the reasons I asked that question in the first place was just because I think we think about wills, especially last testament type of wills, as something we're going to need in our 80s, at some point. And I think it's easy to push those things off. And just part of handling your business well at times can be to make sure that you have things like this stipulated. None of us knows when our time will come. And like you said, it's not even just about assets or finances. It's about guardianship. There's a lot of things that are to be considered. And so it's just something that we can all do well to consider. So,
Right.
So moving on to something else that is, I guess, end of life that a lot of people think about, the topic of life insurance. I know for myself, after leaving Jehovah's Witnesses, there was a point at which I realized that my mom was my beneficiary of the policy. And for both, I think, my wife and I, and we're shunned. And so I decided that I personally don't want to leave any type of inheritance or any types of monies to a person who's shunning me. Everyone, it's fair to make their own decisions, obviously, as to how they feel about any of that. But so checking beneficiaries is something that we might want to consider. But are there any other things that we might want to consider when it comes to a life insurance policy? And yeah, is there just anything legally there that we might want to consider to protect whatever our values are regarding that policy?
I don't have a whole lot of information about life insurance policies. I think that's a good point that you made. Just make sure that you check who your beneficiaries are. In general, with life insurance, it's for adults. If you have an adult policy, then it's for income replacement. And so you want to think about what your limits are, what your family may need after you pass away. But yeah, I mean, just make sure you check who your beneficiaries are. Make sure you, like, as your income increases, you may need to review what your limits are. And then in general, it's a lot more inexpensive to get life insurance when you're younger. So definitely, if you can afford it, then I would suggest making sure that you have a policy in place just to make sure that your family is taken care of.
That's something that I was introduced to. I mean, the value of life insurance, like you said, it's their income replacements. That certainly, I mean, it can sound very cold, but you're going to be happy you have it if something is there when someone you love passes, and now maybe if you were reliant upon their income, that could be invested and potentially spin off some sort of a replacement if necessary, or whatever the case may be, to give you some time, maybe even to grieve.
Right.
So it's an important thing to
Absolutely.
consider.
Yeah, absolutely. And again, like, definitely get it while you're young and healthy. And then as far as kids, like, if you don't have a lot of means and you have minor children, you may want to think about getting a policy on your children. I mean, we don't like to think about these things, but death happens, and it happens to children, it happens to adults. With a kid, you don't really need to worry about income replacement, but you want to make sure that you have enough to cover their funeral and their burial expenses. So that's another thing to think about. And then with kids, if they're young and healthy, then it can be super, super inexpensive. So good thing.
Life insurance really doesn't have to be super expensive.
Right.
Seems very competitive. So
You're right.
Okay, so moving on from life insurance, then we're going to talk about a topic that some have experienced themselves. Pretty sure I've interviewed someone on the podcast before who emancipated themselves at a young age to some degree. Can we talk about just basically what even is emancipation? That's a term that has been thrown around a lot. What does that mean?
So emancipation, the word just basically means setting free. In legal terms, what you're doing is changing the legal status of a minor to that of an adult. So generally, in the eyes of the law, a minor's parents are in charge of them. So they are, in addition to having these responsibilities to care for them, a legal responsibility, they also are liable for the actions of that minor. So when you emancipate yourself, you're basically absolving yourself of that parental authority, and the law is conferring upon you the legal status of an adult person.
And what does that process look like? I guess, why might someone consider that process, and what does that process look like? How old? Is there a certain age that you have to be to engage in that?
So in Louisiana, you have to be 16 years old. In Louisiana, there's actually 3 types of emancipation. So you can be emancipated by marriage. I want to say 15, the law may have recently changed, but I want to say 15 or 16, you can be married in Louisiana. And once you're married, then that legal status of an adult is conferred upon you. You can be emancipated by an authentic act, which is something that you would get prepared at a lawyer's office or at a notary. It's basically a document. Now, that's a very limited emancipation. It's not going to absolve your parents of any kind of responsibility or liability. It's generally for specific types of transactions, like say a minor wants to buy a car, then that minor and the parents get together. They emancipate the minor just for that purpose, for purchasing that vehicle. But otherwise, the minor status remains as a minor. So one thing I do want to mention, which I think is a great positive of emancipating yourself, is that when you're emancipated as a minor, the parent's income is no longer considered when you file a FAFSA, which is the free application for federal student aid. And so that can open you up to a lot more assistance than you would normally be entitled to if the government was considering your parenting. And so it's a good idea. If you're not getting, if they disfellowship you, they've shunned you, and you're not getting support from your parents anyway, it's a good idea to get emancipated, because you're not going to get that support, and then the government won't consider that income whenever you're completing that application. So you can maybe entitled to a lot more assistance to go to school. So I think that's a really good reason to get emancipated, especially if you're not getting support from your parents anyway.
Wow, that's very important. I remember when I did the episode that I did about how to go to college, there were a lot of people that were questioning, how do I fill out the FAFSA? I don't have my parents' information. My parents shun me. I can't get their information. And there was, and I can't remember off the top of my head, it is, I believe, mentioned in the episode, there were some workarounds for that. But it sounds like emancipation may be one that then eliminates the need for your parental income and just takes that away, so that therefore you can apply based on, as though you were an adult, what you would qualify for without an income at that point, potentially.
Right. And then as a minor, you're probably not going to have like a super large income. And so that will entitle you to a lot more assistance. Now, that's going to require a judicial emancipation, which is the third kind in Louisiana. So this is where you're going through a legal proceeding to be emancipated. This is where you are petitioning the court saying that I'm a minor, and for whatever reason, you're going to lay that out in the petition. This is the reason why I want to be emancipated. The judge is bound to do what's in the best interest of the child. So that's always going to be the standard when a minor is before the court here in Louisiana, at least. And so some of the reasons can be if you want to enter into a binding contract, like say you want to start a business, or you want to buy a vehicle or buy real estate, and you're not able to do that as a minor here. So if you want to do that, you can ask the judge to emancipate you for that reason. If you're not getting support from your parents anyway, or if your parents are bad influence, maybe they are on drugs, maybe they're neglecting you, maybe they're just not taking care of you the way that they should be, maybe they're physically abusing you, or, those sorts of things. Anytime that there's some issue with the parents and already not supporting you, then you can petition the court to confer that legal status upon you, so that you don't require, or they're not required to support you anymore, and you can start supporting yourself. So that's generally the reason for emancipations, but in general, whatever the judge considers to be in the best interest of the child, they say, for whatever reason that you're asking for the emancipation, if it's in your best interest, then the judge will grant it. So there's a lot of different factors that go into that.
That all makes a lot of sense. Out of curiosity, obviously, you can only speak to Louisiana. If you even, I don't know if you have knowledge of this specifically, but when it comes to emancipation, is there a cost to that could be prohibitive to some of the people who might actually need or want the emancipation? Is it a costly process?
It can be, especially the judicial emancipation, which is the emancipation that's going to be a full emancipation. It's going to confer the most rights upon the minor. Again, like I said, there are low-cost avenues to obtain legal services. Check with your bar association, check with the law schools in your state. A lot of times, I'm not here, I don't think I've seen them, but a lot of times, like even the courts will have on their website, you can find forms where they kind of encourage self-help. So you can find forms where you just fill in the blank, and then this is something that you can file in the court. So you may want to check with the court. A lot of times the clerk of court, while they're not going to give you legal advice, they can direct you to lawyers who they know to have to be reasonably priced, or to other services. There are services like organizations like the ACLU. I don't want to get the name. I think it's Southern Legal Poverty Center, maybe. But there are organizations that that deal with specific areas of the law who can provide free or low-cost legal services. So it's worth it to do that research, because there is some cost, but there are some ways to mitigate those costs.
Oh, excellent. Okay. If a person goes through that process of emancipation, we kind of touched on it already. What do you gain and what do you lose? So you're gaining basically adult status, so to speak, potentially as an adult, no longer being attached to your parental finances for things like FAFSA. But are there any other things that we might want to consider that you gain or lose in the process?
Right. So as far as being a minor, the two things that you don't have legally as a minor is autonomy to some extent and capacity. So autonomy is basically, just in general terms, just the right to do whatever you want. And so when you're a minor, your parents are responsible for you. They have authority over you. So you need parental consent for a lot of things. When you emancipate yourself, then that takes away that need to have parental consent for things like, it can be for things like medical treatment. You get to decide where you want to live, what school you want to go to. You get to manage your own money. So you just get a lot more autonomy, which comes with responsibility. And when you go through the judicial emancipation, the judge is going to make sure that you understand what you're gaining, but also what you're losing, and the responsibilities and liabilities that may be attached to being emancipated. So those are some of the gains. And then the losses are that just that parental support, which a lot of times the person has already lost anyway, but parents are legally obligated to care for their children. So when someone is emancipated, judicially emancipated, that takes away that responsibility of the parents to provide them with support, to provide them with a place to live. So you lose that, but like I said, in a lot of instances, that has already been taken away anyway.
Okay. Well, thank you for the explanation of all of that. I think it's a very potentially valid and helpful legal step that someone might be able to take under certain circumstances, if that should arise inside the organization. So let's switch now to our final topic of the day, which is legalities around blood and medical legalities. I know you're not a medical provider, so not asking for medical advice, so to speak. But when it comes to having been in the organization, a lot of us did things like we may have carried a no blood card, the advanced medical directive in our wallets. Perhaps we had I remember they had the durable power of attorney, the DPA forms that were very lengthy for people to fill out and to keep on file in the congregation. Um, are those things still valid that one may have signed in the past and put inside, the congregation files, so to speak?
For the most part, and this is a very generalized
Sure.
answer, but for the most part, yes, they are still valid unless there's some language in there that limits them or gives them an expiration date. They are valid in general until they are revoked. And so you want to make sure that if you have put like a no blood card or an advance directive saying, don't give me blood, if you got that in your record somewhere, you just want to make sure that you revoke it and that you replace it with documents that state what your current preferences are. So you want to make sure that you talk to your primary care physician, just like the My Chart. If you have an advance directive in My Chart, you may have had that no blood card in My Chart. Take it out, upload the different document that states what your current preferences are. So just making sure that your current preferences are widespread, make sure they're known by people who you trust, make sure they're known by all of your medical professionals. And then if you, like I said, if you have that no blood card or that advance directive on your record, even if you don't replace it with something else, make sure that you just make some kind of revocation. It just can be a statement, a typed up, written, notarized statement saying, I revoke this thing that I signed in the past. If you have a power of attorney, revoke that one and appoint somebody else as your new power of attorney, somebody that you trust to carry out the wishes that you currently have if you find yourself in a medical emergency. So just, make sure that all of those documents somewhere written down, it says, this is not what I want anymore. This is what I want now.
So let's say I'm faded. I have faded out of the organization. So I guess that brings up a question. If I am disassociated or disfellowshipped, does that have any legal binding on forms that I may have submitted to that organization? I don't know that. I know that's going off script, but
Okay.
so to speak. But is there anything legal attached to that?
No, I mean, well, as far as the advance directive, that can hold some legal weight, but in general, I mean, like the public at large doesn't know what this fellowshipping is. Like they're
Right.
not, they don't care what your status is, in some religious organization. Now, like I said, you can put your wishes on record. A lot of times, like if you have like a planned medical procedure, they'll ask you like what religion you are. A lot of times they'll tell you to do a living will, just in case something happens, they'll have something on record. But in general, yeah, like nobody cares what your legal status or legal status with the Jehovah's Witnesses is when it comes to
Okay.
your
Well,
medical decision.
let's say that I filled out something a long time ago. Maybe I submitted a DPA, or I had this directive and had it witnessed in the congregation and all the things that they would make us do. But it's been years and I don't even know what they have on file. I'm no longer one of them. They're not going to likely sit down and have a conversation with me. So is revoking that simply a matter of creating a living will or something like that that would supersede and be more recent than anything that is older, and making sure that it is widespread, like you said?
Yeah, so in general, it's a document with the living will or with the last will and testament. A lot of legal documents where you're setting forth what you want. Currently, it will have that language in there that says, "I revoke any previous wills or any previous medical documents that I might have submitted." So a lot of times, it'll have that language in there that revokes anything previous, so that your whoever is relying on that document can know this is what the current status is. This is what their current wishes are.
Okay. Well, that's really good to know, because I know that there's a lot of people out there that have various things on file potentially and don't really know, and maybe they just faded and walked away or whatever the case may be. Obviously, it doesn't matter what legally, it doesn't matter how one walked away, but so this kind of gets into our next question, which is there any way we can prevent Jehovah's Witness family or former Jehovah's Witness authorities from having any say in our medical care should we become incapacitated in some way and they are contacted? So I guess it comes back to the living will.
Yeah, it's just a matter of making sure that your wishes are known, that the person that you would want to make those decisions for you, if you can't, if you haven't stated it in some document somewhere, just make sure that the person that you would want to make that decision is known to your medical providers. As a quick aside, when I was doing research for this, I came upon an article from a medical journal where the physician was basically saying that he had seen a no blood card, and while the no blood stance is purportedly based upon religion, they had a lot of information on the card that overemphasized what the dangers of blood is. And so basically the whole article posited that medical professionals should make sure that the refusal of blood is an informed refusal. So basically just kind of doing like a quick education with the patient, because basically saying this card is misleading you or is, or lying to you about the actual dangers of blood. It's not actually as dangerous as they're making it out to be. So I thought that was really interesting, that a medical professional saw that and could see through what was going on with that. I thought that was really interesting.
It is.
Well, what was the question again? Did you have a question?
Well, I just want to say it is that is an interesting observation by that physician, because he could see that the card itself was misleading. Yeah, how can you have made an informed decision when your information is clearly and obviously skewed?
Right.
So that's a really good point. Yeah, my question was just getting down to how do we keep them out of our lives if we are moving forward post JW in some way? How do we keep the people that, because some people maybe are post JW mentally, but for some reason physically they're still around it. And so it sounds like if you're perhaps in a PMO standing, you may want to have a living will that you have on your my chart or whatever that is private, to supersede anything else. And that's really tough, because a lot of people who may be PMO are physically and mentally out because maybe their spouse is still a witness. This really puts people, it shows how dangerous the affiliation with all of this is, because it truly can mean that they could have a say in a really sensitive moment over your medical care unless you do some things to protect yourself. And it sounds like the living will is the way to do that.
Right. So yeah, you just want to make sure that if the person who's in that line of priority to make decisions for you, if you can't, is a JW and still holds these beliefs about blood being dangerous, and you don't want them to make that kind of decision for you. Just make sure that you specify who's going to make that decision. Make sure you specify beforehand what decision you would want made. Tell your friends, tell your non-JW friends and family, even if you're not, a lot of us lose like our whole social support network when we leave. It could be a coworker, just anybody who you think will respect your wishes, but ideally, like, make your wishes known to your medical providers before it even gets to the point where they have to consult somebody else. Because your medical records are supposed to be private. Only time they're going to go to somebody else to make a decision is if they can't get that information from you.
So I know you and I had talked ahead of time about, is there something we could do? As Jehovah's Witnesses, we carried the no blood card. Is there something we could carry that would effectively be a pro blood card to some degree? Is there something that we could do that we could carry with us that might make us feel a little more secure in these instances, that would maybe point to our living will or point to the existence of updated terms to some degree? Is there something that we could do there?
Yeah, so like a little card that you can keep in your wallet. I would probably caution against like having the actual document in your wallet, just because like it has to be in the correct format for it to be legally binding upon the medical professionals. But definitely a card like in your wallet, maybe behind your license, that says, I have this document. This is where it's located. I know in Louisiana with living wills, we can register ours with the Secretary of State. So I don't know about other states if you can do that, but it's good practice to have that document saying, I have this in place. This is where it can be located, or this is the person to contact to tell you where it's located, or to communicate my wishes for me. So yeah, I think it's good practice to have that readily available in a place that a medical professional would probably look for it.
Okay. And so I had submitted a file that I had found to see, I can't remember, I think it was from Vanderbilt University, just pointing to, again, the existence of a living will or a directive elsewhere. And obviously we can't state that this would work in every circumstance, in every situation, in every state, but just as a guideline, would it be something that we could put out there that might give people at least an idea of what something like that could look like? Maybe they need to go talk to their own attorney in whatever state they live in or country, but would that be something that we could put out there?
Yeah, I think that would definitely be a good start. And then again, definitely consult like with whatever legal professional you can in your state, so that you make sure that conforms to whatever your state laws.
Okay. Because it sometimes helps to at least just have something to look at to know what it could be. And then, or at least as a template, because this is kind of an odd thing for a lot of people.
Right.
I don't think that this is something everyone necessarily goes through. There's some specifics here to being an ex-Jehovah's Witness.
Right. It's kind of a well, for one, it's not something that a lot of people think about, unfortunately, until they're in the situation. And then just talking about it can make it seem abstract. So, just looking at a document and saying, oh, okay, it's not this complicated legal thing. It can be really simple. I think that will, having something like that to download for people will be helpful. Just to kind of take a little bit of the mystique away from it, because it's not. I know it can sound complicated, but it's really not as complicated as all that for the most part.
Okay. Well, I'll be sure and put a link to that document in the show notes for the episode, and then people can use that or know that is a less abstract form of something that they could take and then take to their professional as an idea, because it can be overwhelming. Those those no blood cards that we used to carry had all kinds of language in them and links to, I mean, just there's like so many things in those cards. It's been forever since I've seen one. Maybe their latest edition is simplified in some way. I don't know. But I mean, they would fold out into entire full page documents.
Yeah, I remember the old. I've been out for so long. I don't know what they look like now either, but I do remember the old ones. Sometimes, like in my business, I do notary services in my legal business as well. So sometimes people will come in, and when they're taking out their license for me, like I'll see the big no blood card in there. It's, you know, but yeah, I mean, I don't know what they look like currently, but I do remember the old ones.
Yeah, well, it sounds like they might still have something if you're seeing them, and I mean, it only makes sense that they would. I don't know how they go about all of that at this point, but and because when I left, they had just started accepting the blood fractions, and so if memory serves, the cards were even thicker because now they had more options, and you had to write on there what you were willing to take or not take, which was then a another issue because you had to get them authorized and witnessed by other witnesses. So now they knew your business and what you were willing to take or not take. And it really created some friction among the brothers and sisters at times because brother and so felt like you shouldn't take any blood fractions whatsoever, but maybe you differed. And so it was a whole thing. And so I don't know what they've done to mitigate that at this point, but for ourselves, we can, sounds like living wills are something that we really, really, really want to consider. And then of course the rest are good things to have too.
Right. And then it goes back to that concept of informed consent or informed refusal, because how many witnesses like actually understand like the difference between blood and blood fractions? I mean, they're just checking off what the elders say to check off on the card for the most part. So yeah, I mean, I don't know, that's a whole other episode.
Sure.
Yeah.
Well, I appreciate you coming on today and doing this to help in these ways. Do you have anything that maybe I didn't ask you or something that was on your mind that you would like to share beyond what we've talked about so far?
I think we pretty much covered it.
Good. Okay. Well, what if people who are listening have other questions? Obviously, they need to go to their own legal professionals based on what we've talked about today. If there are other questions, just broadly, would you be open to a follow-up if people just had maybe not specifics regarding their state as far as this, but if there are other topics in general that people might have some questions about, is that something that you would be open to helping with?
Yeah, absolutely.
Okay. Well, then I appreciate again your time and taking time out of your weekend to be here today to give us at least a starting point on some of these discussions, and I'm sure it will help a lot of people.
Thank you. Thanks for having me. I hope it was helpful.